Washington, Executive Council, pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker, the Honorable. Vice is the Honorable Sir Georges, Jr. So with that, we will call your first witness, Peter Feldman.
Where shall I?
Right over, right next to Steve, please.
Very good.
Steve, Peter, how long have you been practicing?
Since 1981, I was admitted just in the last days of my.
Wow, so you've been, yeah, I know you've been around a long time.
I've been around a long time, and I've actually given my notice and have backed out of many cases. I think in the bankruptcy court tomorrow, I have a motion to withdraw a hearing, but largely done at this point. It's coming up.
All right, tell us why we should vote for Stephen.
Good morning to all of you. It's my pleasure to be here today to give you more information about Steve McClenon, and I offer this to help you in your consideration of his nomination to the Boston Municipal Court. I've known Steve for over 10 years during our shared time as private counsel defenders for the Public Division of the Suffolk Lawyers for Justice. I've observed him in the variety of interactions we all have with clients, with court staff, police officers, other attorneys, and judges, and always found him to be attentive to his work, collaborative in sharing his perspective on the court's business and on the law. He is a tenacious advocate for his clients, and I've seen him advance his arguments in multiple strategic ways, always working to make his points, whether at trial, in motion hearings, and in the general scheduling maze, which happens in every unit of the Boston Municipal Court. In addition to our shared time in the courts, I've recently come to know Steve's love of the water. As you may know, he's from Seattle, Washington. They have a lot of water out there. And we've gone kayaking multiple times, most recently in October to a place called the Whitehall Reservoir in Hopkinton, just a short distance out of water. In our time, after our time paddling, we went looking for food. And in Holliston, we spotted a Mexican restaurant, locked ourselves at a table, and we ordered. Within a few minutes, two other folks came into the restaurant. The first was a firefighter, and he was squiring a younger boy with him who clearly had some special needs, maybe autism, possibly Down syndrome. But this kid was seriously inquisitive about Steve's unusual gait and lots of questions. In the background, the firefighter was running the embarrassment interference, hand signal apologies and everything. And all the while, his charge was asking Steve about the leg, to see how it worked. Steve couldn't have been kinder, took all the questions and more. This boy's curiosity was satisfied, which coincided with the delivery of our food. In that incident, I came to appreciate Steve's humanity and patience in a situation he couldn't fully control, but which he could use really as a teachable moment for another person. I suggest to you that this is a skill that not everyone has. The ability to speak across a chasm, not only as the voice of unquestioned authority, which is something we often ask judges to be, but as someone with a special perspective, the willingness to take that time to communicate his point. Steve will be a unique person in the judiciary. I urge you to vote in favor of his nomination.
Thank you very much. Any questions? No?
Thank you.
The next witness is the Honorable David Weingarten. You've been here so much lately that the security at the front gate called you a counselor this morning.
He did ask me if he'd seen me before earlier. Chairman Jubaville, members of the council, again, for the record, I am David Weingarten, the first justice of the Roxbury Division, and thank you for the chance to come here again and see you so soon. It was just 3 weeks ago that I came to speak to you in favor, in support of Judge Ham's Superior Court nomination, but I'm going to repeat one thing that I said there, which is that It's always an honor to have a chance to speak to members of the council, and I'm again especially honored to have the chance to return to you to speak in support of Stephen McClennon's nomination to be a judge of the Boston Municipal Court. I've known Attorney McClenon for more than 15 years, for some time when I was a lawyer, and mainly during my time as a Boston Municipal Court judge. I was appointed to the bench in 2008, and I've had literally hundreds, if not thousands, of opportunities to be with Attorney McClenon in the courtroom for arraignment, bail hearings, pretrial hearings and motions, civil hearings, and jury trials. But in order to tell you about my experience with Attorney McClenon, what it's been like during that time, I first want to jump from 15 years ago to when I first met him to a time very recently. Late this summer, one afternoon, I received a telephone call from a member of the Judicial Nominating Commission, a very experienced criminal lawyer, and without mentioning the name of the person he was calling about, he began to ask me about a specific trial that a lawyer had had in front of me many years ago. He started by saying that the trial had occurred a long time ago. It was a domestic violence case in which the defendant had had some mental health struggles. And at that point, I interrupted him. I said, "Oh, that was a trial about an incident that occurred on Mass Ave. The defendant was having a difficult time controlling his behavior in the courtroom. He did clearly have some mental health struggles. And he asked the court, he asked me after jury selection, if he could have new counsel. I asked counsel what counsel's position was, and counsel acquiesced, saying that the defendant deserved to have an attorney in whom he had confidence. I denied the motion. Without missing a beat, without any protest, without any complaint, the lawyer put his head down and vigorously and skillfully tried the case to the jury, which returned a not guilty verdict after a very short time deliberating. After the verdict, the defendant turned to the lawyer and in the courtroom said, "Wow, was I wrong? You were amazing." The defendant was right. The lawyer had been amazing. The lawyer was Stephen McClenon. That trial stayed with me for years and was why I was able to interrupt the Judicial Nominating Commission member to say that I knew who he was asking about without being told, because in that one case, I saw everything that would come to define what I have now known for a long time about Attorney McClenon. That he was thoroughly prepared, that he was masterful as a trial lawyer, that he worked for the best for his client, even when the client had publicly rejected him, that he respected the order and the dignity of the court to continue with the case without complaint and redoubled his efforts on behalf of the client, and that he understood the case and the community in which the case arose so well as to be able to serve the client and the court with integrity and intelligence. Since that trial many years ago, I've come to know Attorney McClenon as a person who will take any case assigned by the court, no matter who is the client or how difficult is the case. He's a worker. He's always well prepared. He's able to walk the line that the best advocates walk, in which he combines zealous advocacy with respect for the court and opposing counsel, as well as respect for witnesses and victims of crime. He's also a person who understands what it means to work in a court where the overwhelming majority of criminal cases involve appointed counsel. That is, where the client, always poor, and in Roxbury, usually a person of color, doesn't have the opportunity to select their own lawyer, thereby adding another layer of difficulty to an already complicated relationship. He has a tremendous feel for the courtroom, understands criminal procedure inside and out. He's going to be able to handle criminal matters from day one. And even though his presence before me and before our court all these years has been mainly criminal in nature, that has not been solely the case, and he will also be able to handle civil cases. So he's already handled many civil cases in the context of representation of defendants in restraining orders and harassment prevention orders, which are a steady diet of all BMC civil sessions. He has, at the court's request, handled many Section 35s, the court's process for the commitment of alcoholics and persons with substance use disorder. And as my colleague Judge Donnelly from Brighton said to me, Attorney McClenon is a lifelong learner. He will embrace learning about other kinds of civil matters. I predict that learning will not be difficult given his breadth of experience and knowledge. He has handled his cases with skill, compassion, and a deep understanding of human nature, which will already put him far down the road in handling civil disputes between private parties. Attorney McClenon has excellent relationships with staff. Every single person whom I've told that I was coming here today is thrilled, not happy, thrilled that Attorney McClenon had been nominated. He is more than well-liked in our court. He's beloved. There is a buzz in the courthouse about his nomination, a happy buzz. Kathleen DeStefano, an assistant clerk magistrate who's worked at Roxbury for more than 30 years, described Attorney McClenon as a sweetheart, as someone who is, good morning, as someone who is smart and works incredibly hard, someone who gets people, and is a man who is passionate about his work. I also want to stress to you how pleased my colleagues at Roxbury are about Attorney McClennon's nomination. Judges Poole, Fiandaca, Del Vecchio, and Breen, to a person, responded to the news of his nomination with one voice. It was something like, "What a great choice by the governor." Everyone recognizes Attorney McClennon's booming, friendly courtroom voice, his happiness about his work and about being in court, his solid friendships with co-counsel, opposing counsel, and courthouse staff, and his skills as an advocate. He's been in the trenches for years doing the work that is done in the courtrooms of the Boston Municipal Court. Our cases often require the application of law to situations that are muddy, unclear, or imperfectly represented to the court. The people who come before us have many times been buffeted about by physical, psychological, economic, and social problems that make solutions to the problems their cases present sometimes very hard to find. They need a judge who will listen with compassion and openness, but also be willing to make hard decisions and hold people accountable. They need a judge who understands how all the pieces, the defendant, the victim, and the community fit together. Attorney McClenon is that kind of person. He may not tell you that because he has so much humility. When I congratulated him on his nomination, I could hear in his voice how moved and honored he was to have even been nominated. If he is fortunate enough to be confirmed by the Governor's Council, a Judge McClenon, bring that humility to the bench and to the community. He will exhibit wisdom and empathy. He will not back away from hard calls or tough decisions. He will be embraced by the court community. I respectfully offer my highest and happiest support in favor of his nomination.
Thank you, Your Honor. That's very well said. Thank you. Councilor Devane.
Good morning. Thank you. I love coming here.
I'm so pleased to see you. Quite a tribute to the nominee to have you here. Is there any one case that stands out that he made such an impression on you?
Well, I won't repeat, it was actually part of my remarks, and I won't repeat the whole story, but I will say to you that the answer to that is yes, and it came up when the Judicial Nominating Commission member called me to ask about an anonymous person and started to describe a trial. I said, "Oh, that's Steve McClenon," and I was able to re-describe the trial back to him from many years ago because it made such an impression on me about a lawyer handling a very difficult situation with aplomb, integrity, and depth of experience and knowledge.
Being here means a lot to me. Thank you so much, and thank you for your service.
Thank you.
Thank you, Judge. Appreciate you coming. See you again next week. Are you going to be back? Okay. No more witnesses for. Any witnesses against? Any witnesses against? Hearing none. You have the floor. By the rule of brevity here, you have the floor to convince us why we should vote for you.
Absolutely. Well, thank you, Councilman Jubenville. Other members of the Executive Council for taking time to consider my nomination. I also want to thank the Judicial Nominating Commission, Legal Counsel Robert Ross, and Lauren Green Petrino, who has been really helpful in just walking me through the process. Obviously, a special thanks and acknowledgement goes to Governor Baker and Lieutenant Governor Petrino for placing my nomination before you. I am Stephen William McClenon.
Take your time, relax.
Sit down.
I'm the son of Dolores and Willie McClenon, who adopted me when I was 4. I wouldn't be here without them. And so anything today that you find valuable or worthy or good, it's a direct result of their sacrifices and the values that they've instilled in me. So it is, always has been, always will be my desire to somehow be deserving of what they have given me. I apologize to you. As I stand here, it's interesting what led me here. And there are 3 pivotal moments that I point out to that I actually arrived at this location. The first was when I was working in industry. I graduated working as an engineer down in Texas in a chlorine plant. And during those couple of years, I was thinking to myself, well, what is it that's going to make me happy? What is it that, I guess that, what gives my life meaning? And it was pretty clear then, and it always has been clear, that most of my joy, most of my happiness comes from helping other people. In some ways, it's selfish. The feeling I get when someone else is helped. It was at that point I decided the best way to do that, the most effective way to do that, was with the law, and went off to Boston College Law School. The second epiphany or pivotal moment came when I was working in the district attorney's office in Middlesex County under then District Attorney Tom Riley. I was in the court, and I realized at that moment that this is what I wanted to do. I love the courtroom. I love trial work. I love my clients. I love the people. And so I knew that was going to be my contribution. That's how I would help people through the trial court as a trial lawyer. Been in private practice for 26 years, come across a lot of people. You learn a lot. And probably the last, most recent moment, and actually probably the most unexpected moment, was about 5 years ago. A good friend of mine adopted a 5-year-old boy named Jay. Giovanni. And I had the honor to kind of be his role model. He calls me Uncle Steve. So he's like a son. What's interesting is that my interactions with him, he's 10 now. So for the last 5 years, my interactions with him kind of make me rethink, kind of a new start, because kids just think way outside the box. And we get, in our own little channels. And so interacting with him and seeing him grow and seeing how I have to teach him. And what's interesting is when we get to the point of mistakes, I say mistakes are good because it teaches us what we don't know. But how do we make better choices, Jay? What are other choices we could make? And that is directly relatable to my clients. Because a lot of them, I don't know how they were brought up, but we all need help. And then the choices they make. So how does a person help them make better choices? And it's almost a direct correlation. And so when I come before you seeking to be a judge, it's because it's a continuation of that thing that happened 35 or 36 years ago when I said I wanted to help someone. And I hope as a judge, I have a few more tools available to me. But it's a continuation of that help. And I believe I bring a unique set of skills and background that would enhance what is already a wonderful court. I have to say, and do apologize for not being totally together, but I'm humbled, truly humbled by the opportunity to appear before you with the possibility of an appointment. And I recognize that it's not a joke. Sometimes it's been overwhelming. With that, I welcome the opportunity to answer any and all questions that you may have about my background, my qualifications, or anything you'd like to know about.
Thank you very much. Councilor DePaolo.
Thank you, Councilor Jubal. Good morning.
Morning.
Starting out as an engineer and then ended up in the practice you did, I would look at you and guess you were going to go into patent law or something along those lines, right? So I guess you answered the question, but was that something you considered when you talk about helping people? Were you thinking criminal law when you went to school?
No, I wasn't. And I was thinking patent law. I actually did an internship briefly up at Franklin Pierce Law School, which was in the patent and trademark area. And I worked at Procter & Gamble in their patent department writing patents. It's a very isolatory job. You do not deal with people. It was because I had the science background, but it clearly wasn't a fit with my personality. Not saying you can't help people doing patent law, but you don't get that interaction. And you don't really see it when, a big company, Procter & Gamble, produces a new surfactant.
So far upstream from your impact, right? And on the bench, you would have immediate impact, right?
Correct.
So when you talked about some of your clients and how they ended up with you and before the court and about helping people in the perspective of watching a child grow, what's an example? How do you imagine yourself helping on the bench? You see a lot of clients dealing with, for example, mental health issues or substance abuse disorder. What do you see as a opportunity for you to help as a judge?
Sometimes I know the studies show that when someone is put into a drug treatment program, they have a better success rate in terms of moving forward. Many people don't want to go. Sometimes it's giving them an option and saying, hey, here's something that you can do. And I don't want to call it a carrot and a stick, but urging them, hey, this is something that may help you. Then they go in and then they may find that, hey, they are helped by it. Exposing people to ideas or things that they haven't thought about. One case comes to mind of a guy, he was about 55 years old, he was an iron worker. And he had an extremely difficult heroin problem. And when I was talking about with him and he's like, oh, I deal with this, I can work. What we determined was that when he was 4 years old, he saw his father shoot his mother in the head and he walked across her body and then he was raised by his aunt. And when I inquired of him, did you ever talk about that? Or I actually spoke with the aunt. I said, did you guys ever take him to any kind of counseling and discuss that? She said, no, we raised him. He graduated. He's okay. So there's an opportunity where you can identify, maybe there was something in the background leading to some of the behavior. Judges have the tools of having probation, having programs, being able to offer them opportunities to make change. And I think as a defense lawyer, you're constrained a little bit more. You can suggest as a counselor, but your obligation is to your client and what he wants. As a prosecutor, you're in a different role. As a judge, I think you can bring a lot of the different parties together and offer different type of dispensations.
So sometimes when you have a trauma like you were describing that underlies a substance abuse disorder, as a judge, you would try to recognize that and craft a plan that's going to address the underlying issue so this person doesn't appear before you again.
That would be the best thing for him and everyone else. Yes. If the problem is, how do you find out about it? And that's the harder part.
That is the
You
hard
have to
part.
depend on the.
Right, because as a defense attorney, I'd imagine, or I don't want to put ideas into your mouth. So how do you get to the bottom of that, though? How do you, is it imperative on you as the judge to dig in and discover that trauma that's contributing to things?
I think what you can do is you can try and look at the surrounding fact. You can look at a record and you could say, hey, he's had substance abuse issue and ask why. And then you can make inquiry of a lawyer and ask him, is there some issue that's going on? Is there something that we need to know about? I don't know that it just jumps out at you.
Right.
But you have to try and piece it together. And I guess that's, just look at the pieces. This doesn't add up. Why? And ask that question. And then, yes, you are going to have to dig and ask. Some of that comes from the lawyer. You're not going to speak with the individual directly per se.
Right. And that kind of digging, that kind of curiosity that the 10-year-old has is the kind I'd love to see the judge as well be after that.
Well, I think that the whole thing about this, I don't want to call it a fresh start, but looking at things anew, as opposed to staying in your lane where you're always seeing the same thing.
I'm not going to belabor my questions, but I appreciate your perspective and thank you, Mr. Chairman.
Mr. Kennedy.
My phone's been ringing off the hook since you got nominated with people. A lot of people. The one that stands out the most I'm going to mention is Diane Maldonado. I have an incredible amount of respect for retired appeals court Justice Maldonado. Appeared in front of her many, many times in Chelsea. Not that smart. She explained how close she is and how close you are to her family and how much respect she has for you. And that obviously means a lot. That said, I've known you for almost 30 years, I think. Pretty close to it, isn't it?
It's gone by quickly.
Yeah, it sure has, you know. I think I had here then. I don't know if you did, but I've seen you in court countless times. I've seen you try cases. I've seen you appear in front of judges. I probably could have been one of the witnesses for you in terms of how qualified you are and how much compassion you have for people. And I absolutely vote for you. You're not even a close call.
Yeah.
Thank you, Mr. Chairman. Chairman McClenon, I thoroughly enjoyed our very long and detailed conversation that we had. Would love to have another at any time. I don't want to say I don't have a lot of questions. We really went deep into a lot of legal, social justice issues that are very important to me. I care, I believe very deeply, as I shared with you, that that already as an attorney, but if you ascend to this position that, we need to model for folks, and it should be held to a higher standard of truth and civility and decency. And I think you concurred with me
I do.
on all these issues. It's pretty clear that the stuff that I care about and that we all care about, it's not just me, but I sort of root for the underdog, person who doesn't have the privilege and opportunity that I have been gifted in my life. I'd like to say thank you for acknowledging, the parents who raised you and the sacrifices that they gave to make you the man that, or help form you into the man that you are. It matters. If your mom is watching or gets to watch, I hope she knows that you're an outstanding person and lawyer. I personally, because I have a background in my previous life in technology, I love that you're an engineer. I love when we get the guys like you. Chemical engineering is a little bit different. Could be helpful to us in maybe some drug cases. You never know. But it's a different way of thinking, and I can see how that thought process could be, frankly, advantageous in a court case. There's right and there's wrong, and then our life experience helps form us into how we go at that. I will ask you this though. What do you anticipate might be your biggest challenge sitting in a district court?
To be honest, the real thing I thought about more than anything else, and not to take the question in a different route, but as a solo practitioner, you make your own hours, just get the work done. And judges, I think, they're required to be there 8:30, 5:35, 4:35. So I think the biggest change, the biggest thing is going to be time, that this is how your schedule is. That's a change. And then I think if you want to call it a challenge, I guess I would have called it more of an opportunity. Because I'm slightly excited by the ideal of just being able to do or preside over civil work. I understand the rules of evidence, but to see the procedural aspects, required finding a directed verdict motions and summary judgment motions, what I'm saying. So I actually would like to add more of those to my tool belt, if you want to call it that. So I think that's, I guess we can call it a challenge. I kind of think of it as, I don't want to say fun, but it's an opportunity to learn something.
Every challenge is an opportunity. In my world, in how I choose to live, every challenge is an opportunity. That doesn't mean it's always easy. But as we discussed before, I like to learn, but I also like when someone can actually change my mind. You know, one of the smartest people, I always say, there's a woman I'm still friends with, she now lives in New York City, but I knew her in DC, and she was and sometimes she would just say these crazy, outrageous things. But then when you'd sit and you butcher on it, you know, she did that to sort of get you going, but she could really break it down and change my mind and make me see things differently, and instead of in, you know, the world that I have lived in. I've done something doesn't mean that's how it should be done. And I think, you know, I think you're open to that as well. I also, I don't think you mind acknowledging the fact that you have what some may call a disability of immobility. I think that's very, doesn't affect why you're here or not, but I think it's very important because it brings an awareness to the bench and to the courts, which we are pushing. You know, we keep talking about diversity. Differently abled people are diversity, and diversity includes everybody. And it includes, you know, I've talked a lot about access to justice. If we don't have good public transportation, if you literally can't get to the court, you don't have access to justice. But if you can't get up the stairs, you don't have access to justice. You know, Michelle Wu talked about this yesterday in her inaugural speech, which I thought was amazing. You know, that now they literally have physical access into some of these buildings. So I find that, I guess, good, you know, but to bring awareness. The thing I will ask you publicly that we did speak about privately is, I think it's very important for folks who are passionate about justice, which I think everybody in this room is to model and to speak to younger people. We keep talking about a pipeline. We need a pipeline. We need a pipeline. And the way to build the pipeline is for us to get off our duffs and get into those classrooms and talk to kids, show them who we are and what they can be. And maybe someone's not going to be a chemical engineer. And maybe somebody's not going to be a lawyer. Might be a court officer, be a clerk, you know, but they may also not be any of those things. But if ever they have an opportunity or an experience where they have to go into a courtroom, maybe it won't be mystical to them. Maybe a little bit demystified. And I really believe, and you know, as many of the councils in this room have done this. We've done hearings. We've done some public hearings in our districts. Bring it to the people, right? And so that's something. If ever I call upon you and you're able, I hope that you would be one of those folks that would be willing to, you know, talk to younger people and just open their minds and let them think. You know, thinking is, we're so blessed to live in this country. We're so blessed to live in this Commonwealth. We're so blessed, since we're on this YouTube, we're so blessed to have a governor's council. And you have pundits mocking us at times. Oh, abolish it, abolish it. But you know what? We don't get the nonsense that they get in other states that we're watching play out in the national press right now because judges are elected in other places. Folks like you have to jump through a lot of hoops before you even get to sit in that chair. And the public should know it. It is, as you said, this is no joke, and nobody in this chamber takes this lightly. We understand the public trust we are charged with. And so, you know, bless the Commonwealth of Massachusetts for having the foresight, and bless every single one of my colleagues, frankly, for the mockery we take from people sometimes for our job. But this council, this executive council, this governor's council, particularly at this time in history, it matters more than it has ever mattered before. And it's like I said, we're watching this play out on the front pages of the paper right now. And we don't get that kind of nonsense here in Massachusetts. And when it happens, it ends real fast. So thank you for being somebody who has applied. I told you I would give you a speech because I'm Italian and Irish and I do that. But thank you, because with your background as a chemical engineer from Howard University, one of the finest universities in the country. I went to college at the other end of Northeast DC. I know Howard well. A lot of people don't. It is, as we would call the Harvard or Stanford of African-American universities in this country. It is as fine of a school as exists in the United States. So as a graduate of Howard, and then to be an attorney, you could be making a lot of money, something else. Thank you for choosing public service, because we need people like you, and I deeply appreciate it, because frankly, it's a little bit of a sacrifice, even though you may not feel that way because it's a passion. But thank you so much. Mr. Chair, I have no other questions.
Thank you, Council Ferrero.
So Ferrer's not here.
Oh,
Hi, Joe.
Thank you, sir. Thank you, Mr. Chairman. I just want to say that I spoke to a lot of people, including Councilor Kennedy, who's a huge fan of yours, and others. I know you've overcome many, adverse situations in your personal life as well, and you should be very proud of your parents. Did a great job raising you. I want to thank you for your service as an ADA. Great job. I think you're going to make an outstanding judge with the compassion and empathy that I'm told that you have, and I can see it today as I watch you remotely. So you do have my vote next week, and I think you're going to be a terrific judge. Thank you.
you, Councilor Andrew.
I have a few questions. Congratulate you. You were conducted this hearing with cases surging. Monday to Monday, last week, COVID cases have surged 30% in this state. 30%. Cases are up, hospitalizations are up. But I just want to commend you and the nominee. Very few people here, and I do appreciate that. We're in a small room, and I know it's hard. A lot of this, I'm sure he could have, but I want to personally thank you for being a servant due to the circumstances that's going on in the state. Graduated from law school in '93 from Boston College.
Sure.
Great law school. No.
I loved it.
I think it's good. When you look at that, you want to do some more reports in the class one, you made one from it. It's a great law. Yeah, you graduated, okay? I hope that the rest of the company gets later. You're a sole practitioner. Working for yourself at that point. That's pretty impressive. How did you start getting clients? I mean, I got a good one out of law school. It's not easy.
No, it's not. And the first 5 years was somewhat difficult. Obviously, people would refer me clients, but as most solo practitioners probably know, that's when I did the most civil work that I've ever done, because you take whatever comes through the door. In doing that, you learn a little bit about divorce, a little about landlord-tenant, you got some debt collection. Problem is, you don't really, unless you have volume, which is hard to develop, like, as you said, getting clients, it's hard to really become a master of one of those crafts, and you become a generalist, but you have to pay the bills. At that time, though, I was able to go to appointed work, and clearly, we all have our talents. I was just drawn, being pulled that way, because that's where people were, that's where you could help. But it was difficult the first 5 years, but word of mouth, putting your card around, friends, but you do just about anything. After that, you find your footing.
I told you right now. You got law school in '93. in those days, I know it's different now, you know, I got out of law school a few years before you. I also did a court appointment. Those days, when I started out, you know, you go to this courtroom, that courtroom, I remember being in the BMC on Saturdays. Yeah, Boston Municipal Court, they had the session on Saturdays, it's way like 40 on that. And, the judges, if the lawyer is sitting in the first row, the judge is like, attorney so-and-so, take this client, attorney so-and-so. Well, I know it's different then. You started out, how did you get cases court appointed was?
Basically,
What was it, the judge?
the judge would assign them, but there were one or two of you there, and the judges I had, they give it a 1, 2, 3, and then
But now that's changed now.
still something similar. You have the duty attorney. Yeah,
Now it's the duty attorney.
Yeah.
The judge.
yeah.
I'm just curious when
Oh,
you-
yeah, you were given a specific day. Yeah, back then. Oh, okay, you're saying you were just there.
You know, I could show up at the BMC, I could show up at Roxbury, I could show up at Dorchester, you know, I could do anything I want. And the judge would say, attorney so-and-so, you get this thing. I was just curious when you started out.
No, it's,
You know, the duty-
I always had a duty day.
So I was before you. I guess, you know, and the government and the administration, it's just 2 in a row now. Have sole practitioners. I'm a big fan of sole practitioners. And why is that? And you alluded to it. You know what it is to pay the rent. What it is to pay the electric bill, the phone bill. You work for yourself, and sometimes you can't pay these things on time because it's difficult. You bring it back?
Absolutely.
And I've always been a big fan of sole practitioners to become judges, because when you're in a court, and let's say we're in the criminal session, well, it's the sole practitioner oftentimes against the government. The government has unlimited resources. You don't have unlimited resources as a sole practitioner like yourself. You know, if you're sick, or you want to go on vacation, or you want to be in another court, it's a struggle. Most sole practitioners don't have other lawyers in the firm, they're all by themselves. So I hope, and I believe you will be, you'll understand that when a sole practitioner comes before you, and maybe it's late for court, because he or she was in another court. Or maybe, that, some practitioner wants to go on vacation with his family. Your thoughts on it?
I've had situations where I've needed to be at a hearing in another court that just came up over the weekend, paying client, and you're supposed to be in court on Monday. And I have to say that most of the judges that I have come in front of are okay with you coming in later or having a further call. What I will say, respectfully to them, is they really appreciate it if you just call ahead and let them know. It's when you don't call and you show up at 11 that I have found those to be the problem. But when I've called and said, I have a conflict, I need to be in another court, the judges I've been in front of have been very, very accommodating. Because it is, as you just said, well, there's $2,000 I need to go make for this hearing, and absent a trial or custody, they've been willing to do that. And that is something that I agree with you. You don't have coverage as a solo practitioner.
Totally agree. And I don't go to court anymore. But, well, that's a good thing.
Well, I know what that means.
Whatever.
Okay.
But I think stories from Kennedy, yeah. Successful, criminal lawyers in the state. They're the best, nobody gets better than these two. But I hear stories from them that they can't be at honestly 2 places at the same time. So can you believe, I had a case with so-and-so, it's assented to motion to continue the case. I mean, come on. A judge so-and-so, or judge so, whoever, we got to appear 4 days before the article of the motion. For sole practitioner, that's a heavy burden. I feel it's ridiculous. you should be able to have a second vote or continuance. You shouldn't have to show up a week or 3 or 4 days before. Your thoughts?
I think in most cases, I would say I agree with you, then if it's assented to. I suppose if you looked at it and said, this is the 7th time it's being continued, you may have a question. But for the most part, I don't think it should be an issue. I agree.
But if you're on the 7th time, I assume in the motion, file motions to continue. They're going to explain the reason. They're not going to just say a rule of the beach. They're going to say something, you know, I don't know what. I mean, I got a federal one. I got a Social Security disability case, which is a federal case. You see that in the motion, the average defense like time, but it's legitimate to me.
You just, I think you expounded on it. This is why, obviously, and it's assented to by the other party. You're right. I don't see where there would be an issue.
You know, the last 3 or 4 weeks, I've asked this question to all the nominees. They've all given me the answer that I was told. They would give me. I had the answer first.
Okay.
Simply, well, I shouldn't say recently, it's come to my attention recently. It's with respect to personal injury cases, and I know you don't have a ton of experience on that. You know, the legislature a few years back gave plaintiff's attorney in their closing arguments, after the case is over, to say to the jury, I think this case is worth whatever, 10,000, 20,000, 30,000. Years ago, you couldn't do that. You couldn't specify an amount. Okay? So it's come to my attention, you know, I'm downtown Boston, so the water lawyers here. They're gonna have, it's not a lot of judges, and it's mostly in Superior Court, but what happened in the district court? Some judges, if the, in this situation, if the defendant's attorney files a motion, you know, before the time, and asks the judge, I want to know what the plaintiff's attorney is going to ask the jury, request to the jury a monetary amount. You follow the question? You follow this so far? Most judges are saying no, no way. We're saying 80% are saying no way. Okay, that's, I'm not going to say. But for the judges who allow it, okay, so they know, they go first. The attorney goes first. And then the plaintiff's attorney goes second. And he said he wants, say, 50, 30,000. And a lot of judges, I think say a lot, definitely the minority, will give the other side an additional 5 minutes. And it's crazy to me, an additional 5 minutes to argue why the $25,000 request to the jury was too much. Maybe it should be nothing, maybe it should be 10 grand, whatever. Okay? Or, and I think that's wrong. Everyone I've asked in the last 3 or 4 weeks has agreed with me. You know, says this, the plaintiff's lawyer says this, that's it. Okay? You follow where I'm coming from? I want to know if the defense attorney asks you. I want to know what this plaintiff's lawyer is going to ask the jury. But the legislature, when they did this, they could have said, you know, the plaintiff's attorney can ask a monetary amount. They could have said, and then the defense attorney can rebut that. The legislature didn't do that. Okay? So, your thoughts?
My thoughts is I'm a little out of my water at this point. My first honest answer would be each side had their opportunity. There's no reason to continue. So my first reaction would be no. I don't know what the reasoning or theory is behind allowing the other party to come back. So I can't tell you that 1,000% I'm not going to do it, but my inclination is to say no without understanding why.
I can think of some reasons, but to me, they're not valid reasons. Again, it happens mostly in Superior Court because you're obviously the dollar amount is much greater. But I think it gives an unfair advantage to the defendant side, which I don't like. And have you handled any personal injury cases?
In the first 5 years, I did do a personal injury claim for a passenger in a vehicle in a left turn, and I was unsuccessful.
In the passenger?
Yes.
In a lot of personal injury cases, and not a lot, I take that back, it's not. You know, the defense attorney will file a motion for summary judgment. Again, my experience, I've been doing this a long time. I don't know, people poll, but 90%, 95% of judges deny those motions. Just because, hey, let the jury decide. Let the jury decide. So again, I know you're not that familiar with these types of cases, but I hope you keep that in the back of your mind. Let the jury decide, not the judge. You know, again, I'm a strong advocate of the little guy, the disadvantaged guy. If someone gets injured, you know, through no fault of their own, I don't like the judge throwing the case out. Okay, well, let the jury decide. Again, I'm a strong advocate of that. We have a lot of criminal cases. We've done a lot of that. Again, I'm one of those people who like to give people a second chance, maybe a third chance, give a chance. So I'm a fan when it's appropriate. Rehabilitation as opposed to incarceration. Your thoughts?
I would agree 1,000% with you. I think the goal is to rehabilitate and to move them beyond so that they don't come back. I think there's also, you know, they talk about deterrence as well as punishment, but the goal, I think, always should be to improve the person's status. So I don't, and I would even go as far as to say that I've had the pleasure to be before judges who give people a fourth and a fifth chance. So long as those people are trying. I think that the operative word, are they trying to do better? And if so, then you give them that opportunity to.
And remember, when they try, they're gonna fail. They're not gonna be 100%. It's gonna be
Correct.
to be successful, there's gonna be failures.
Absolutely. And I think that comes into play, as I have seen, with clients who are addicted to controlled substances. They do well, they fall, they get up, they do well, they fall, they do well, they get up, they fall. And I think so long as it's not a public safety concern, I think you just keep working with them as long as they want to work the program.
Well, you know, that's good. I think you're gonna be a great judge of the BNC. You have the educational experience, you have a lot of criminal experience. You seem to me that you have the right temperament. You seem to be compassionate, which I like. Sole practitioner, I like even more. Everything about you, I like. Obviously, there's going to be a little learning curve, but no one has everything on the civil side. A lot of good people get to be a city and always ask. It's a pleasure to see you, and your name comes before us at the next section of the voting.
For Hurley.
Good morning. Sorry I was a little late, but I had a chiropractic appointment that I did not want to miss. We had a great conversation. As a matter of fact, probably one of the most important conversations I've had since I've been on the council. I liked your attitude as it relates to the protection of people who are victims of violent crimes and domestic abuse. You've got a good balance between your time in the DA's office and the years you've been a defense counsel. I think you're going to make a great judge. Terry Kennedy raves about you, and he doesn't rave about anybody. So, did you hear that, Terry?
I heard you, man.
As far as not having a lot of civil experience, don't worry about it. You find that the judges who you serve with are very, very helpful. And I think the one bit of advice that I gave you was don't ever make a decision or let anybody aggravate you to the point where on the bench saying something you don't want to. Take a recess. Same thing if you don't know the answer, take a recess. Call one of your mentor judge or, somebody that can be out. But you've got a great demeanor. You've got a great disposition. Adversities that you ever overcame as a child were amazing in terms of your dealing with your cancer and just, it doesn't say enough about you. It speaks volumes. So I think you're a wonderful candidate. I'm glad that you explained to me what the United Schutzbund Club of America was, which is dealing with and training a dog the right way, which is something a lot of people should take advantage of. So all in all, you are one of the best candidates I've seen. So I don't think it's any secret I'm going to vote for you next week. And I thank you for your service.
Councilor Devaney?
Defense attorney. Well, he called on you.
Councilor Devaney?
Thank you. I can always count on being called last.
They're the best ones.
For sure.
First of all, I just want to say, asked to have the same respect that we gave Councilor Iannella. I'd like to say thank you to councilors here who are present, 6 councilors, Councilor Iannella, Councilor Duff, Councilor Kennedy, Councilor DePaula, Councilor Hurley, and the district council presiding, Councilor Jubenville. We all came in here because we know it's safe. And I thank the witnesses, the 2 witnesses are coming. We have decided that one person who gave a medical letter from her doctor, Councilor Hurley, would be on Zoom. And Councilor Hurley comes.
That's not what she decided.
She had the vote.
Sorry.
Excuse me.
Hey, excuse me. One person has the floor. You have the floor to ask questions. So ask your questions.
HIPAA violation.
And so I just want to say that Councilor Hurley is the only counselor that comes on Zoom because he got the medical letter, so I want to make that clear. First of all, you made me cry to start out with. I'll tell you, in 21 years, and I mean this from my heart, I have never, ever, and I meet with all nominees from parole board to judge in 21 years. I've never met anyone like you. I mean, your history, your personal life to get you here, if that isn't the American dream, I don't know what is. So when I meet with a nominee, sometimes it's up to 4 hours, I never, ever divulge here in public anything personal that is said. It stays at the diner. I asked you if I could have your permission to talk about your life experience, because I know you won't say it, and I think people should know. Because I'm voting for a whole person. You're qualified, you're well experienced, but I want people to know the person. Hope I get through this without crying. Okay. Your mother was a 15-year-old. And thank God she didn't have an abortion. She didn't keep you. She gave you and you were in a foster home. You were loved. They became your sisters and brothers, and your foster mother had you as an infant until you were 4 years old. And as a mother of 4, I can imagine the bonding that you had. And then one day, someone came to take you. You were going to be adopted. It was a 4-year-old note. You cried. Your foster mother did not want to give you up. So these are the things that you have gone through all your life, you know, sacrifice and change. And your adopted father said to your mother, maybe we should give him back. She said, no, he'll get through it. And you did, and you have a special bond with your mom. And you lost your dad when you were 20. But, you know, that is an amazing story to know that, you know, to get through all that. And then to have cancer as a young man, to lose a leg, and then to go through all that pain again in college and have it go to your lung. All of this is so amazing that makes you the person with the compassion and empathy. And I had to say that story because it is remarkable. It is remarkable. And if I was your district counselor, your mother would be sitting here. I'm sorry. She is so proud of you. And I just feel, you know, that your story should be told because everything that you've done is what makes you the person that you are. And I just wanted to say that. Okay, so I asked all the nominees your journey about judicial nominating commission hearing interview. So there are 21 lawyers who have the awesome responsibility appointed by all governors to decide who is going to get an interview, who is going to be chosen to be recommended to the governor and come before us for a vote. So to me, looking at the past, looking at past JNCs, they took it serious. They took it seriously. So I want to know how many of those 21 lawyers who had that responsibility were there when you had your hearing?
I believe there was one present in the room with me, like the assistant chairperson. And I want to say on Zoom, on the screen, there were 10 or 11 other members.
Yeah. So there's my point. And it goes nowhere because they're not listening out there because there's something wrong with this JNC. And this administration, there never has been 21 lawyers who hear nominee for a lifetime position. And I can't do anything about it. I only have the ability to vote yes or no. And it doesn't apply to you, but I have nowhere to go to say it. So that's why I'm saying it. So anyway, you're here. And I couldn't be more pleased. There's no one more deserving. You have the age, 56, you have the age, you have 28 years as a lawyer. I love private practice. You understand the responsibility of paying the rent and shoveling the snow and all of that. But so you chose who you were going to represent. It wasn't just given to you. So you also had the experience as a lawyer in the district attorney's office. So I think, you know, that's great experience. So I'm going to ask you one that really stands out, a case that you had. And it stands out so much that, you know, I got calls from Judge David Greer, Judge Donnelly, Judge Maldonado. I never pronounce her name. I'm sorry.
Maldonado.
And they all said the same thing, but one of them brought it up and I brought it to him and he talked about it, that you really didn't expand in your JNC. And Judge Donnelly told me, how you handle a case with dignity. I've been here 21 years. I've never heard a nominee's witness or anyone in a letter saying that this nominee had a case and he showed dignity. That's a wonderful thing. And it was a man who was throwing out expletives. He had the He raised his middle finger. He threw tables over in court. He did everything, yelled at the jury, yelled at everybody, hated you. And you got through that. And now I don't want to tell a story. You tell
Just use his first name. His name was Eddie. He's a gentleman who had a lot of anger issues. He fired two previous lawyers who were both women. I was asked to represent him. The case originated in Roxbury, but had to be transferred out because it took place in the Roxbury court, the actual subsequent behavior. We went to Brighton to have that trial. Mr. Ray was less than diplomatic. He had made threats to me. He wanted someone who was going to represent him and represent him well. We had a trial. Ray made comments about the district attorney and his relationship to the judge, and a lot of outlandish behavior. 2 counts of intimidation of a witness, 4 counts of threats. They brought in a few extra people for security, and he throughout the trial just continued to berate witnesses. At one point, he berated the jury who was going to go out and deliberate. And I think the good thing about that trial, and I give Judge Donnelly worlds of credit, is I could look at him and he understood I was trying to keep my client together, but that we were going to get through this trial because we were just going to get through the trial. And so a lot of it he let slide. He directed things at me, but clearly not, it was directed at him. It was just a very trying case. And the behavior, I think, had it been another judge, would have never gotten through that. He would have been taken into custody, or he would have been, locked up, gagged maybe. And we were able to get through the case, and
friendly.
yeah, we were able to get through it. And actually, we did okay. We won 4 of the 6 counts. But I learned a lot from Judge Donnelly. Just stay focused. Let's get through this. But the behavior was somewhat reprehensible. But he's still my client. So.
You don't get many cases like that, but I know, that's what he said. He said, you went through and dignity, and, I think that's the greatest compliment you could get, really. Now, when one of the things is that I like your background. I like that you have both of the criminal part. I think it's very important. I have my own philosophy that if a lawyer is a judge and he's never had a criminal case, I think he or she would be timid in talking about sentencing or anything like that because they never had a defendant. So I don't know if you agree with that or what, but I think criminal experience is important.
I'm going to say yes, because that's what I do. I think all experiences are good, but I do think criminal experiences inform your opinion in terms of dealing with people and understanding where they come from. Maybe it gives you a little bit better insight, a little bit more empathy. And so I'm not going to argue against criminal lawyers. I think they should be on the bench.
Well, I'm going to go back to how your personal life interacts with the lawyer that you are and how fit you are to be a judge. You volunteered to do this 100 years, to pick up a child, bring him home, feed him, take care of him, play games with him, bring him places. And that to me is compassion. I mean, to come out of your world to help someone on a personal level like that, to take up your time, that meant a lot to me. And I'm able to divulge the name of the person who was the mother of that child, and that was
Maldonado.
So, that tells me, and you have done a lot of pro bono work, and that means a lot. You don't see that in a 40-year-old when they come. They don't have that pro bono work. Tell us something about some of the things that you've done.
Well, you call it pro bono work. I guess I just call it just representing, sometimes you represent people who have no representation. Other times it's something as simple as going to the Roxbury Community College to help someone fill out financial aid forms because they want to. I think it speaks more to the fact that I just think we all of us just need to be a little bit more helpful to each other. So I don't know that I have any specific things that you do, but you do what you can for people.
Well, I don't have a poker face. I can't stop smiling that you're here and you've been appointed, and I thank the governor for, for doing that. Now, just for people to know, I mean, your background, as a prosecutor, you had approximately 45 to 50 criminal cases in 3 years. You probably had 80 or more cases in 24 years as a defense counsel, and you've had bench trials. I mean, I can't help but to say it. This is what we want. You've got the age, you've got the experience, you've got the qualifications. This council voted a month ago for a 40-year-old, and he had 2 jobs coming out of law school. One was he was one of 13 assistant solicitors in the city hall and worked in the office of sheriff. He's gone to a court that primarily has a lot of criminal cases in Worcester. He's never seen a criminal case. I wish it could get through to the governor, lieutenant governor. Look at these J&Cs. Look at these applications and see if you want a 40-year-old like that when we have someone like you. And there are people out there that are rejected. So you can get an interview. I know. And my heart breaks and I can't do anything about it. But I just want to say we need people like you. You have it all. So I usually don't say that at a hearing, but I can't help it. You are unique, So as I said, I like more criminal experience, and you've had enough of the civil that you've had enough experience. The thing is that I like is your philosophy, that you don't think you just sit on a bench and make judgments. You want to go further to help that person, to see how you can help them, whether it's a drug court or veterans court or whatever. That's what really impresses me about you. And I have gone to drug court graduation. They're wonderful. Aren't they wonderful to see these people who have for years been addicted and now they're working, they're free and telling their story. It's remarkable. So tell me what you think about how important those, those kind of courts are, especially the drug court.
I think the drug courts and the mental health courts and some of the other specialty courts are a good thing. I will say specifically, I like the drug court because it is a court where I don't think if you're addicted to a substance, it's not quite the free choice that I'm going to go rob the 3rd floor for somebody. You're struggling with something, and I like the drug courts because they let you fail and they bring you back, and they let you fail and they bring you back, and the good folks in the drug court, there's no limit on the number of times that we're going to help you back, because it's a process of working through it. So, and I think these courts sometimes look into some of the things that have happened. I know with the Veterans Court, when you think of some of the trauma, some of the veterans who've actually seen combat, to be able to recognize that and see that some of the behavior somewhere else. So I think those courts are important. I think that gets us to that place of we do want to rehabilitate as opposed to just cage someone. I think, and probably to say it, but I'm going to, when I had my dog, you put him in a crate to teach him potty training. You didn't put him in a crate to lock him up or to punish him. You put humans in crates. And so if we can do something besides that, where public safety is not the issue, then I think we should. And I think those courts start to address those things. So I think they're positives.
Now, when you are a judge, you want to see changes. What do you plan to do? What do you think that you could, introduce
I don't know if I can introduce it, but I think I like the new technology that's come out of the pandemic of Zoom for non-evidentiary hearings where we're getting dates and things. I don't know if I can do anything about that. That may be more an administrative issue. But that's something I like to see kind of brought in. You know, I've had clients in South Carolina who are flying up here for one date and nothing substantive is going to happen. So I think that's something that we need to think about incorporating. Also, I think it saves money and time for solo practitioners like myself. So, I mean, those are some of the things. As far as the judge on the bench, I think the best thing he can do is, I think it's important, and I think this is the thing I always look for in the judges that I kind of admire, is can you listen and let the person understand that they've been. Because I think when you're about to tell someone something they don't want to hear, like I've told clients, if they feel that they've been heard, that they truly, you understand what they're saying, then they receive everything else better. And I think judges, if they let, and I don't know, every judge is different. Let the person before you know that you hear them. Not agree with them, but you did hear them and you heard what they had to say. I don't know if I can bring more of that to the bench, but I think that's important.
Now tell me, you did apply twice. In 2012, you were 47, buddy?
Yeah.
47.
46.
Now tell me, looking back at that experience and now, what have you learned in those 9 years to make you a better judge? And, you know, that you were not chosen at that time, both from the JNC and the governor twice.
If I might say, I believe the application I put forth at that time was a strong application, and I think that I had the abilities at that time. I think over the last 10 years, obviously, and I said this, my little statement is that I know, at least within the last 5 years, I've really had a renewed ideal about how to think, and to really start over, think outside the box again, because of my little nephew, Giovanni. I also, you see more, you learn more, you interact with more people. Like a wine, you mellow out, you age, you're able to see. I think I've become even in those 10 years, a better listener, and a better communicator. And I think those would transfer well to the bench. And I've also seen the law evolve a little bit more. And I think that my skill as an engineer, my background as an engineer, is helpful because we're starting to see science really, it always has, but it's leaking into the court more and more. And when I say that, I think of things like cell tower technology, metadata, you have the DNA, you have tool marked firearm identifications, and then you have the soft sciences, the behavioral sciences, the early childhood brain development, you have implicit bias. You're seeing more of that coming to court. So I've had an opportunity to kind of experience that as some of those cases have just come down within the last 4 or 5 years. So I think I'm just even a more complete.
But you know, when I look at your experience and your employment, looking back then, you were qualified then. You were qualified then. And this is just frosting on the cake, I think, what you've done, you know, since then. You know, the thing is that it's your compassion that comes through. That and you know, and you talk about you know, the most significant experience that you had was with that 5-year-old and picking him up in school and feeding him and doing his homework and teaching him games. I mean, that was really, you stepped up to help her out with her son. And, you know, she will never forget that. She is so, you know, indebted to you. And she says that's why he'll make such a good judge, because he has that compassion, you know, go that extra mile to help people, you know?
Thank you, but I'm actually one that's kind of benefiting more by it, believe it or not. It's a great learning experience. I'm indebted to him.
But, you know, that question, you know, why do you want to be a judge? Yours was different. Yours was different. And you said that you want to make a positive impact on individuals and communities. A judge can provide support and structured opportunities to individuals to support their ability to make better choices. I see becoming a judge as a logical next step in my career to build on my nearly 30, or it's over 31 years of experience of working towards fair and equitable outcomes for all. I value the opportunity to contribute my diverse perspective and divergent life experiences to improve the quality of judicial decisions and to enhance public confidence in our justice system as an impartial and accessible institution. You can't get a better answer than that, and that's from your heart. I really, So, and again, what you're putting in your resume too, as you said, you're able to draw on a unique perspective as a person of color who lives with a physical disability and a Boston resident. That's the whole thing. That's great. So, yeah, it's just amazing. And I wish that all of the applications read this way, but unfortunately they don't. And you're not this thick either, with all your experience. And so, when you say that people should be treated with kindness, empathy, and politeness in court, that doesn't always happen, you know? I love the idea about mentors. Now they're mentoring new judges. I wish they'd mentor some of the old ones. So what do you think about that program?
I'm not in it, but I hope to be. I think it's a great idea because you get a chance to observe, you get a chance to learn, really get a chance to ask questions and find out how the job is done. And I think that the more individuals that you have to draw on, the better. The more opinions in the room, information you have. And I think if you have that chance to deal with different judges, see how they view things, that just adds to the store of your own knowledge, and you can hopefully use it to make even better decisions when it's your time.
But what I got through your application was your relationship with your parents and the influence that they had in you, that they gave you the confidence that you could do this and to go to college and go to law school. Tell me about how that affected you.
Yeah, my mom was a registered nurse and my dad was a pipe fitter. I guess I'd say just briefly, basically not going to college would have been the thing that would have been unexpected. So it was just understood you were going to college. And my dad was kind of a different kind of guy. And I always tell the story just quickly, when I was a sophomore in high school, right after I had lost my leg, he came to me out of the blue in the summer and said to me that, if you don't go to school, you can't live here. And so I respect the fact that he never allowed me to make excuses. So I think it's just, they wanted better for me. And they just had expectations. And so I try to live up to those.
Well, they're proud of you. Again, I'm sorry if I was presiding, she'd be here. Anyway, you know what? And it's from your heart that the people you represent, as you said, they are financial, emotional, and often have physical restraints. All of those, that's really the basis of your practice, who you represent. So, I just, I think, you have seen the mental health of veterans and you're concerned with people and drugs. There's so much more I could ask you, but, I've said it, I've just said it, that I've never met anyone in 21 years that came with a life experience to overcome all the physical, all the pain, and I just respect you so much, and I'm looking forward to hearing how well you're going to do on the bench. And thank you for applying. Third time, people out there, please apply again, because sometimes political people jump the line, and you're here, and I thank you. And it'll be my pleasure. It'll be after Thanksgiving too, when we vote. Thank you so much for all your time. It was such a pleasure to meet with you, and you're like the Belgian waffle. Okay, thank you.
You, you're gonna be doing some jury trials. You've done a lot of them in your career, right?
Right.
So I saw on television yesterday, in a nationwide broadcast of a trial, that the judge, when it came time to pick the alternates, had the defendant come up and reach into the barrel and pick 2 or 3 or 12 or whatever, how many he had to pick in that case, rather than have the clerk do it. And I said to myself, it's a pretty good idea. It's his trial. So he gets to pick the alternates. And the other side of it, there's no complaints if you don't like the pick, because you picked them. Think of that.
If I look at it from a statistical perspective, it's random. So I don't know that whoever puts their hands in and pulls them really matters from that perspective. So I don't think you get an unfair advantage from that. I don't know, thinking about it, is there an image issue with the idea that he picked them as opposed to some other party? My gut says it's random. So if you roll them in a box and you pull them, if he pulls them, you pull them. I don't think it has an effect on the trial. Does it send a wrong message? Does it suggest something to the jurors that remain? I haven't really, I saw that yesterday, too. I'm not sure.
What message would it
I
send?
don't know. Does it send a message that a judge is trying to say, oh, I'm siding with the defense counsels? I don't know. I'm not saying that it does. That's something I would have to think about it to answer that honestly. But just from, it's random, doesn't matter who picks them.
I mean, since 1780, when we've been picking juries, the clerk picked it. So I did see a judge pick one once. But to me, defendant's on trial. Defendant's charged with a crime. The jury's there for the defendant.
I can't argue with that. It's random.
So when you're on the bench and I have a jury trial with you, guess what? I'm going to ask that the defendant pick the alternates.
I will probably say yes.
I don't like the probably in.
But I don't want to be an absolute. Because you never know.
Probably means you can slip out of it.
And that's true.
Okay.
If you come before me and you ask me that, I'm going to tell you yes. Let your client.
All right. Now, here's the other thing that I noticed recently in the last couple of weeks. You know, we've had the Zoom for almost 2 years now. And there's been so much talk in the courts about the good parts of Zoom, not doing trials on Zoom and not have witnesses on Zoom, none of that stuff. But the everyday stuff, it's estimated about 20,000 people go into our court systems a day throughout the Commonwealth. Half of them probably leave by 10 o'clock with another date. And they miss a day's pay at work. So Zoom really helped that out. For non-evidentiary issues, picking another date, a C&E for a trial date or whatever. Obviously, if you're going to do a plea or there's going to be a trial or there's going to be a motion to suppress it as evidence, then the defendant has to be there. But I noticed in the last week or two, all of a sudden, we're getting back into everybody's got to be there at 9 o'clock. I recently called the clerk's office, spoke to an assistant clerk, and I said, the matter I have on, can we do it at 2? Oh, no. She said, no, court starts at 9 o'clock. So judges don't work at 2? They're not on the bench? Well, yeah. I said, well, Superior Court does it, so why can't the district court do it? Instead of everybody rushing in at 9 o'clock, a group comes in at 9, a group comes in at 11. If you want to put it on at 2, fine. Judges are there at 2. But it seems to be kind of slipping away now. We're getting back to the old habit. Waste everybody's time, make sure people miss days of work. What's your sense of that? Have you seen that or heard of it?
Yeah, yes. Still a defense lawyer. I actually agree that we are going back into the everybody shows up at 9 o'clock. Even before COVID, was of the belief that maybe there should be more, opportunities to waive the client's presence at some of these hearings. That's the first part, something that I had thought about when they're non-evidentiary and you're dealing with motions and discovery. And I even thought even with Zoom, you could space it out that so many people would be called from 9 to 10, 10 to 11, 11 to 12. I, as a lawyer, as a sole practitioner, think that makes the most sense.
You said it makes the most sense. Everybody said it makes sense during the pandemic. Everybody was saying, we're going to save the good parts of Zoom. And all of a sudden, I'm just talking district court. I'll write down.
I think change is hard. People don't like change in general. And I'm going to assume the courts, they stick on to their traditions as well. But I agree with you. I think it's something that would make things more efficient.
Well, I think it changes when judges change it. Right?
They have the authority to
The
mandate.
judge says at arraignment, okay, what date you want? You give him a date. Okay, the judge should automatically say, look, he's represented by counsel. No need of you coming in. We'll have you come in on a Zoom or conference call for your next event, because it's a pretrial conference. So, many times nothing gets done at a pretrial conference. So I think judges, and you're going to be a judge, so you got to take the credential and go forward with this thing.
And take the initiative.
But if you're going to lay back and let the chief judge of the court say, no, you can't do that, then forget it. You got to be bold in this job.
Remember that.
You can't fire you. It's beautiful. Can't fire you. Even if they suspend you, you get paid. You don't lose a dime. So you got to be bold, okay? Otherwise, we're drifting back into the same old stuff we did for 100 years, wasting valuable time, and our clients lose money for their families and for paying rent. It's disgraceful. Forget it. You just need to see a defendant every single time the case is on. I don't get that. I know judges do that. Where's your client? He's at work. Well, he's supposed to be here. He's at work. I'm here. I represent him. An obligation to the court to tell the court if he's gone, if he takes off. If you take off anyway, isn't that your feeling? Maybe 1% of people don't show up in courts. It's so small, I don't even think we should worry about it.
I agree. I think there are many times the client doesn't need to be there. I agree with you.
Well, if you agree, then do something when you become a judge.
If I become a judge,
You could start the new wave throughout the Commonwealth. And when you retire, we'll put a bust of you out on the State House Grand Hall, okay? Continuances. Counselor Ionel asked you about continuances. It always seems to be a thorny issue with some judges. Continuance. What do you need a continuance for? I got another case. I got other things to do. I mean, I'm tied up. It's the problem. I don't get why some judges get involved in it, even get involved in that continuance, unless it's being abused for a certain case. I don't get the problem with continuances. How are you going to be on continuances when you're going to make lawyers drive into the court? I'll tell you a story, true story. I had a case in the Falmouth District Court. Got the case on a Sunday. It was on for Tuesday, first pretrial conference on first offense OUI. Starting the trial in the Superior Court on Tuesday. I called the court on Monday. I send down a letter, motion to continue. Clerk says to me, the judge, he doesn't know whether you're really on trial. Starting a trial on Tuesday. So I said, so he's not going to give me the continuance? He said, no, not yet. So later he called me and said, okay, he's agreed that you don't have to come in, but your client does. The client was a 24-year-old labor, he's a plumber. I take a day off from work, Boston area, drive all the way down to Falmouth to get a date. He already knew the date because when, and the clerk said to me, "You don't have to show up. The date I had asked for is a date that we're going to give." So he had to drive all the way down there, miss a day's work, just to be told the date that I told him he was going to get anyway. So, and then I'm told that some judges require people, even lawyers in Worcester, to drive down to the courthouse, bring the case before a judge to get a continuance. Foolish is that? That's, when I first started 43 years ago, that's what was happening all the time. It clogged up the courts. I believe it's a complete waste of time for the judge. So where, are you going to be?
I won't be that judge.
You won't be.
I will now.
If you're going to be, tell us now because we'll probably change our votes.
You'll get that. You'll get your continuance.
Okay. And judge shopping. Ever hear that term?
Yeah, when you're advocating for your client.
Judge shopping.
Yeah, that's what they say.
What does that mean? What does it mean? I still don't know what it means, but tell me what you think.
I'm not sure what it means either. I think people are trying to do the best for their clients and they're trying to figure out where they're at. Judge shopping to me would be as if you came in and said, "Oh, my case is in front of Judge X," and you somehow can manipulate the clerk to say, "Oh, no, I need you to put it in front of this judge." That to me would be more judge shopping.
Right.
But I don't know too many people that can just have their cases moved. If you're saying I'm coming in and I see I have a judge and I think, well, I'm not going to resolve my case today, I'm going to come back another day, I think that's good lawyering.
Well, what about jury waiving cases? You ever jury waive a case?
Yes, about 14 years ago. There's been a couple I did recently, but it was more of a stipulated facts trial. But I tend to, in my practice, when there's a factual issue and not a simply legal issue, that I would rather put the factual issue before a jury. If it's strictly a legal issue, I would put it before a judge.
So how do you know what judge you should waive a jury for?
Well, people talk, lawyers talk.
You know, really?
Yeah, they actually do.
Okay.
And you get a sense for how they think that judge views certain issues. And based upon those discussions, you make a concerted effort to inform your client. You know, I hear their lens, the lens through which they view things is slightly different than the lens maybe through 6 independent people. And maybe we don't want to limit ourselves to this one lens of the judge. Or they may say, "Hey, I like the lens because he has a wide angle lens. And I think maybe this is an opportunity. I think it would be worth going in front of him. I think they can give us a real good decision because it lens."
Let's do this scenario. I'm the judge. You're before me on a C&E date. You say, "Judge, I would like a trial date." And I say to you, is it going to be jury waived or jury? What is going to be your answer to me?
I'm gonna ask for a jury trial.
Okay.
Why could I not waive my jury on the day of trial if I don't wish to have a jury trial on that day? But why should I limit my option to just a bench trial and not have the option for a jury trial, even if I plan to have a bench trial?
That's a good way to do it, I guess. But what if the judge says, "Look, it looks like you're going to jury waive this. So why don't you do the waiver now and then come back in 30 days for your jury waive trial?" What would you say to a judge who said that to you?
I'd say, "Judge, I respectfully, I think that's a great idea, but at this time I don't want to limit my opportunities here because I want to really confer with my client and make sure he really truly understands. I see no reason to do that."
Why would it be a good idea? Why would you say that to the judge?
I think it's a great idea. If you know you want to have a trial in front of a jury, I don't have to bring in the juries. Maybe I could schedule it for a date on a Monday or Tuesday when we don't even bring in juries.
So okay, that's done. Okay, we'll give you this date, jury waived. But I want your client to do the waiver today.
I wouldn't lock my client into that.
Why?
I got there that day and there was a judge that I knew that I had been fighting with for the last 3 years. And I thought that that judge, he didn't know the difference between, an opinion and an expert opinion. And then I find out, I show up on that date and it's that judge, knowing already what I'm up against because that judge has had a pattern or a history. Then I think I'm doing a disservice to my client. And so I wouldn't do it. I just wouldn't
So,
take a jury trial.
so the only way that you would jury waive is on the day of trial when you know what judge is sitting, right?
When I knew who was there and I could make a good assessment as to, hey, this judge is fair. He may find against you. But I feel, my client, my experience, I guess you'll call counsel, this has been my experience. And so it's your choice, but let me give you the information. And obviously he's going to make the choice, but I'm going to inform that choice, come and say, hey, I have not had success.
It's going to ask you what you think of this.
I'm going to say, I haven't had success with certain issues with this particular judge. I don't think it's in our best interest.
You're being very kind.
I try to be.
Because sometimes I tell my clients, no way on God's green earth would I ever allow you to be jury waived in front of this particular judge who's sitting today. Because he hasn't found anybody not guilty in the entire tenure of his judgeship. Right?
Well, if I had that information, it would make the decision very easy, yes.
Well, you sit around courtrooms and what do we talk about waiting for our cases? How's this judge with a jury waived? How's this judge this, right?
Right.
That's how we find out. And if everybody's got a thumbs down, then you don't jury waive with the guy, right? Or one.
But yeah, I would say that is absolutely correct.
So in the pretrial conference report on the back, it says, check jury or jury waived.
I always check jury, even if it's going to be jury waived.
You know what I write? Unable to make that decision at this time. Because I can. I don't know who's sitting when we come back. Right?
Correct.
And not all judges are on what us defense lawyers call the jury waive list. You know what I mean? Unfortunately. I think it's a sad commentary on a judge who no one ever jury waives in front of. It's a sad commentary going through your career. Nobody ever jury waived in front. Well, I don't have much more. I've gotten a ton of calls also from judges, lawyers, and so forth. And to my way of thinking, good age, so much experience in your life. Just ask you to be kind to the citizens of the Commonwealth. After all, they're paying for all the salaries we're getting, right? And we have more people under lock and key population than some countries in this state. So you judges putting people in jail, in cages. So I'd ask you to only do that when it's absolutely necessary and there's no other alternative. I don't think it helps anybody to go into a jail cage. You, a lot of them come out worse than they went in.
Great.
So anyway, we're going to vote on you next week. I think you can read the tea leaves. I don't think you're going to have a problem. So I don't want you worried about it between now and next week. All right? So don't do any more studying. Things over. Thank you.
Different coming up.
Ready to go.
Yeah.
I am calling our assembly to order. Good afternoon. Nice to see everyone today. And Councilor Hurley, please lead us in the prayer and pledge.
I pray that people have gotten their shots, the 2 shots, now get their booster, protect them more. And for the people who have not had shots or for children whose parents don't think it's such a good idea, I really hope that they reflect on that and hopefully make the right decision for the health and safety of their children. And I'm thanking the good Lord and everybody else for what hopefully is going to be a Thanksgiving this year, where families will be together and enjoy the holiday season as we have not been able to do for far too long. Amen. Pledge allegiance to the flag
United States.
of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. I recognize Councilor Iannella for a motion to record advice and consent for the financial warrant.
So moved.
Second. There's a motion and a second. In favor, say aye.
Aye.
And I recognize Councilor Devaney for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So moved, Lieutenant Governor.
There's a motion and a second. All in favor, say aye. And I recognize Councilor DiPaolo for a motion to record advice and consent for the appointment of Pacifico M. DeCapua Jr. to the position of Associate Justice of the District Court.
Happily so moved, Lieutenant Governor.
Second.
Second.
There's a motion and a second.
I just want to say that I'm really pleased, and I want to congratulate the administrators to choose this nominee. And today, 56 years old, he has a lot of experience. I got a lot of calls. And to have Judge Eustace and Judge Calagiani to recommend him, there's not enough said. Even in his community, he was very involved. And even I got a call from one of the selectmen there in Milford, and he talked about how he sees him at church every week with his family and everything. So he's just a good person and well qualified. Thank you.
We may begin the roll call.
Yes.
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 Pleasure, yes.
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 Thank you. We have a new nomination today. Christine D. Anthony has been nominated to the position of Associate Justice of the Probate and Family Court. This falls within your district, Councilor Devaney.
I just want to preface my remarks to say that I haven't got the results of my redistricting. I've lost Westboro to Councilor DiPaolo. So this may be my last Westboro, appointment that I will be presiding over. So I have set it for, I didn't hear it.
I was not if you were giving it to Bud.
Okay. So I set it for December 1st at 1 p.m.
Point of information, if they're voting on it today, does that affect it for the hearing?
It would be effective in January.
Okay. All right, what was that date?
December 1 at 1 p.m.
Thank you. That concludes our business today. We're not on for the next one. Okay. So I wish you a wonderful Thanksgiving with your friends, your family, in good health. It's going to feel a lot different than last year.
Coming in next week? We have to cancel the caterer, right? Caterer coming in?
Well, send them to my house.
Your address. We'll send it.
Great check. All right. Thank you, everyone. Have a good holiday.